Good morning.
Hi, good morning.
Good morning. Good morning, General Director. Good morning, Consul General Alicia Kerber from Mexico in Houston. Thank you, everyone, to be here today. It's a pleasure to have you. Mr. Velasco, can you hear us well?
Yes, I can hear you perfectly.
Okay, excellent.
Thank you very much, Alfonso, and hello to everyone.
Please, it's really our pleasure to have you here with us today. Welcome, everyone, to this seminar where we would like to discuss the opportunities and challenges the new USMCA is putting in front of us for hopefully a very prosperous relationship, and we would like to discuss with you today. So before the introduction, my name is Alfonso Lopez de la Osa. I'm the director of the Center for US and Mexican Law. Thank you, all of you, for being here today. There's a couple of logistical aspects. If during the presentation of our panelists, any of you would like to make a question or do a comment, please use the chat that you might find, may find in the Zoom system, so that after in the Q&A we could answer all your questions. Be sure that you have your the system working and that you can do this with the chat. I would like to do a small introduction about the topic today and then move on to the presentation of our speakers so that we don't lose any time and we can take the best advantage of their knowledge. So as you know, the USMCA, the CUSMA, the Canada, US, and Mexico Agreement, as it's called in Mexico, or the TEMEC, as it's called in Canada, sorry, as it's called in Mexico, the TEMEC, Tratado entre México, Estados Unidos y Canada, was signed on November 30, 2018 in Buenos Aires during the G20 summit there. After the signing, as you know, according to the international law procedures, the ratification process opened in each of the countries. So that the agreement entered into force. That's very relevant when we talk about international law and even international law basics, the difference between signing, ratification, and entering into force that are normally spaced in time, and something that it's signed doesn't mean it has already been ratified or entered into force, which opened a moment of some kind of doubt about how the ratification process was going to be after the signing in November 2018. Mexico actually was the first country to ratify the agreement on June 16, 2016, with some changes that were introduced afterwards on the labor side and on the environmental side. We will see all that today. And those modifications were later ratified again on December 12, 2019. Canada ratified the agreement on March 13, 2020, and the United States had ratified the agreement beforehand on January 29, 2020. Again, this ratification didn't mean they were going, the agreement was automatically entering into force. There was a deadline, the first day after 3 months. So meaningly, basically that the effective date of the agreement, so as we speak, was on July 1st, 2020. As you all know as well, in the middle of the COVID-19 pandemic, the USMCA agreement, entered into force. What did it mean? It meant that for the goods entered or withdrawn from the warehouse after that date, the USMCA would apply. For any good that would have been stopped or whatever reason would have been just going out from the warehouse before that date or initiate the process before that date, we would apply then the NAFTA agreement. With the USMCA, well, new chapters have been introduced, changes as well have been included in what was the NAFTA dimension, and also some procedures are impacted. Actually, there's the four more impacted industries on the USMCA are the automotion and automotive parts, manufactured goods, textile and apparel, and agricultural industries. But to situate the topic today and to see all these aspects that we would like to approach, let's just make some question as the hypothesis de trabajo, as the problématique, as the French say, or the question we want to ask, what is the strategic vision of the treaty, of the USMCA? Why do we need to, or did we need to update it? Do tensions between the USMCA countries exist after that? What are they? Can we address them? How? What are the new chapters that have been introduced? For example, what are the new criteria for the automotive goods or for the automotive sector? For the agricultural industry? Is it said something about dairy, beef? How is the textile and manufacturing industry affected? Are the new enforcement mechanisms? What are they? What are the changes to enforce the dispositions of the treaty? So many questions come to our mind. I'm sure that we are going to find a solution, or at least clear them today. And I would like, without further ado, introduce our guest speaker today. Thanks to the generosity of Haynes and Boone and for the organization of the Center for US and Mexican Law at the University of Houston Law Center. We are so welcoming today Roberto Velazquez Alvarez. He's the Director General for North America. Mr. Velasco holds a Master of Public Policy from the University of Chicago, where he was the Chicago Policy Review's Editor-in-Chief. He's also, he has a JD from the Universidad Iberoamericana, the Ibero-American University in Mexico City. He has an extended experience in Mexican federal, state, and local public sector, and before being appointed to be Director General, he was Strategy and Policy Coordinator for ProMexico, NAFTA Regional Director in Washington, D.C. So after the election, he was invited to join the Director General for Public Affairs and afterwards the Director General for North America position that he serves today. So really, it's a pleasure and an honor to have you, Mr. Velasco, here today with us. And without further ado, I would like to give you the word so that you can present your vision about the USMCA. Thank you so much.
Thank you very much, Alfonso, for this kind introduction, and thanks to Ed and Roberto, who are also joining us, and obviously to our Consul General, Alicia Kerber, who I saw also is connected. I'm very grateful with the University of Houston for this opportunity to share some ideas about the challenges and opportunities we are faced in the context of the COVID-19 pandemic and the USMCA. I would like also to recognize the University of Houston as an invaluable ally in the academia of both North America and the Ministry of Foreign Affairs. We're also glad in the ministry to have your support and collaboration, particularly in the development of the Master of Law program for members of our illustrious Mexican Foreign Service. As we all know, we're currently living in a very complex situation, to say the least, which has prompted greater regional and global collaboration at all levels in a relatively short time frame. We see international cooperation as the best tool to transition to a better future, and we acknowledge the USMCA in particular as the starting point in North America to boost and consolidate these efforts. And let me start by talking generally about the USMCA. As you know, this agreement is the result of a high level of understanding, integration, and cooperation between Mexico, the US, and Canada. After a very, very complex negotiation, we reached an agreement to modernize the 25-year-old NAFTA into a 21st century high standard agreement, which is in accordance to the current times. We are convinced that this modernized agreement will support mutually beneficial trade, leading to freer markets, fair trade, and a more robust economic growth in North America. As you probably know, This agreement accounts for more than $1.2 trillion in trade, affecting 500 million North American consumers in what is now one of the world's largest free trade zones, representing 28% of the world's GDP and 16% of international trade. The trade among the three countries is on the rise still, and we are sure that will provide further economic growth to the region. In 2018, for example, the trade between the two countries exceeded 1.25 trillion, which was an increase of 8% compared to the previous year. This agreement, we believe, has the very important characteristic of keeping the guarantee to the free flow of trade and investments in the region, while strengthening our competitiveness, the regional value chains, and economic benefits for the three member countries of this very important agreement. We believe that the current trade is reflected in this new agreement. And let me talk a little bit about some of the features and innovations that are included in it. The agreement seeks to advance towards a more inclusive and responsible region, driving North American competitiveness and guaranteeing certainty in trade and investments, which was something extremely important for the businesses in our three countries. It is also the first trade agreement that incorporates elements that address the social impact of international trade and enables the participation of even more sectors in the economy who traditionally were left behind. And let me mention a couple examples. It is, from a perspective, the first trade agreement that contains certain protections for workers' rights. It provides still some protections for the environment in the side letter on environmental cooperation. It also incorporates obligations to fight corruption in a new anti-corruption chapter. And it promotes inclusion by integrating gender equality-oriented provisions in some of its chapters, as well as a very important new chapter on small and medium enterprises. Obviously, there are many challenges that the three countries will face, particularly in the middle of a pandemic like the one we're living. We have one of the most institutionalized bilateral trade relationships in the world between Mexico and the United States. And I'm sure we recognize each other as both strategic partners and close allies in a variety of topics. Obviously, in these kind of times, our cooperation and our ties are challenged, and this partnership is also reflected by the resilience that we have witnessed in the past few months. For example, we were challenged to collaborate among authorities and stakeholders at the federal, state, and local levels, not only on health and medical issues related to the pandemic, but also in other subjects of bilateral interest. And it is very important to say, I think, one of the biggest challenges that we've faced during this pandemic is that we had never before, fortunately, put to the test the level of integration of our supply chains in the region. And this is the kind of thing that we know in the academia, at the theoretical level, that this is something that is going on. We talk about products crossing the border 8 times before they are finished. But we had never actually witnessed how this is translated into real life impacts when you have a shock as the one we had when we had to close or shut down important parts of the economies in the three countries due to the pandemic. And obviously, as in any situation as complex as this, the three countries did our best efforts to attend to our populations and to take care of our citizens. And that meant that we all built different interpretations of what an essential industry was. And that created multiple problems for businesses that we had to attend, working both with the businesses, the representatives, businesses associations, and also obviously between the governments. And happily, I think we reached a point where we were able to keep afloat some of the essential supply chains that were vital for feeding our people, for allowing the medical industry to provide itself of essential products for attending to the pandemic and other public health issues and so on. So again, this is something that we didn't have a playbook for. We didn't have any guidance on how to deal with something as complex. I wish we had, and I believe that one of the outcomes of the pandemic will be that all the countries will have to think about these issues very, profoundly as they relate to the national and the national security of the countries. So this is an outcome that is important, and in the case of North America, I believe it highlighted the resilience of our partnership. Obviously, along with the US and Canada, this is something that we remain committed to working on. And we are convinced, as I said at the beginning, that North America's economic comeback after the pandemic hinges on using the USMCA as a framework for regional and local economic growth, supporting supply chains and creating thousands of jobs. We also believe that the success of the agreement will reflect on one of President López Obrador's economic priorities within his broader plan of transformation of the public life in Mexico, which is the development of more inclusive economic growth in regions that still have a significant lag in development and welfare in our country. That you probably know is one of the biggest issues that we're facing as a Mexican societies. Obviously, we are all aware that the success depends on the participation of every sector and actor in our communities. So the agreement explicitly allows for new sectors to participate. As I said, for example, a small, medium enterprises, and obviously the gender equality provisions and provisions that have to do also with indigenous communities and migrant workers. So, and with this, let me talk a little bit sort of what's the view behind the treaty as a country, how we think this was a good strategic idea, a good match with our priorities as an administration. I mentioned the inclusiveness and the development of different sectors of Mexican society, because what we saw during the previous years with NAFTA was that a part of the Mexican society was lagging behind. Not all the workers shared the benefits of trade, and that created important tensions among our workers and our society. And there were tensions as well between the workers of our three countries. We had workers in the US and Canada that felt that there was unfair competition because Mexico was lagging behind in the enforcement of its labor standards. And we had labor standards, for example, that had to do with the freedom of union that were different to those that were being applied in the US and Canada. And this is something that President López Obrador talked about many years before he became a president. So we saw in the USMCA an opportunity to address this issue between among the Mexican society, but also between the three countries to create fairer conditions for the workers. But also, and this is very important, with an economic idea behind it. And what's the economic idea? That we want Mexico to add more value to the products that we export to the United States. We don't just want to be a platform for bringing products from other latitudes into the US tariff-free or to Canada. We want to add value to these products in Mexico in a greater extent. And we believe that that way we will foster a greater integration of the supply chains in North America, because together as a region, we can, again, add more value and build products of greater complexity between our three countries. So, for example, the new rules of origin in the automotive sector have to do with this vision that we can bring larger parts of the supply chains to Mexico and to have products that are built between our countries to a greater extent. So the USMCA creates a more level playing field for Mexican, American, and Canadian industries. But also, as I said, we believe it fosters greater integration because Mexico, fortunately enough, not only competes in the international market because of its cheap labor, and that is something that we don't want to happen anymore. But we also are a highly sophisticated country with a very complex manufacturing industry that is building now high-tech manufacturers, for example. So we believe there's a great potential to increase this integration in the North American region and compete in a greater extent with other trading blocs in Asia, for example. So again, as I said, and let me start closing with some of these ideas. The USMCA gives continuity, certainty, and stability to trade and investment flows, which obviously was one of the main objectives that we had from 2017, August of 2017 and on, when the renegotiation started. But we also believe that the North American market remains a window of opportunity for investments and businesses in the global scene. The economic integration of North America has resulted in great economic benefits, but we want to increase the social benefits that the treaty provides for our country. It has allowed for the creation of several production chains that have become fundamental for the competitiveness of our region in sectors as manufacturing, automotive, and agriculture, among others. And we want to strengthen the middle class and create good, well-paid jobs and new opportunities for the nearly 500 million people who call North America a home. We believe that there are still sectors with very high potential in Mexico for new diversification, such as industrial machinery and optical, medical, and other devices that we believe will develop and grow steadily in the following years. We still believe that Mexico is fundamental for the automotive industry to keep a healthy path towards growth. This industry will certainly be a fundamental pillar of economic growth and development in the region. And we remain committed to working with our partners in this sector. And we also think that the inclusion of e-commerce in the agreement will also create very important opportunities in this new area that was not covered in the NAFTA for different businesses and companies. So we are at a crossroads of the decisions that we've taken during this crisis that will have a long-lasting impact. But we are convinced that our region can build a path to a brighter future through continued dialogue and collaboration. And let me just finish by saying that the NAFTA removed for the first time the tariff barriers for trade between our countries. The USMCA maintained that policy. But what we've seen in the past few years is that non-tariff barriers have also played a crucial role in not allowing sometimes trade to grow as much as it could. And particularly the main non-tariff barriers that we're facing are the crossing times at the border, which is how most of the products flow between our countries. So Mexico and the US have acknowledged this situation, and as part of the agenda for the implementation of the new USMCA, we have a very ambitious border crossings and infrastructure plan that we're working very hard on, and we believe that from December of this year on, we will start inaugurating some important works that we've been doing together for the modernization of our ports of entry. And hopefully we will have some new ports of entry in the coming years. So with that being said, thank you very much for this opportunity, and I look forward to hearing your comments.
Thank you very much, Mr. Velasco. Really, indeed, a very clear and full of hope presentation, of course, in the middle of a pandemic. And I really believe Mexico is a key player in North America due to, of course, the different aspects we shared and because of the tremendous potential as well as a leading country in Latin America as well. So as a decisive associate for the United States in that sense. So thank you so much. Without further ado, and so that we can afterwards leave space for the Q&A, I would like to introduce Ed Lebo. Ed Lebo is a lawyer from Haynes & Boone. He has a very large international dimension. I was happy to learn that he speaks perfectly well French, and I'm a very close French-speaking person. And he's very much business-oriented and cost-effective and targeted in his work. He has a comprehensive dimension of the perspective from the legal services, and he has advised several U.S. industries in aspects such as OFAC sanction, export control, of course, NAFTA, anti-bribery issues, and so. Without further ado, I would like to give the panel to Ed Lebo that would give the dimension or the perspective from the legal side of the legal practice in the United States. Thank you very much and welcome, Ed. Thank you for being here.
Thank you, Alfonso, and welcome everyone. And thank you, Director General Velasco. That was very insightful presentation, and I'm looking forward to seeing the increased border crossing capacity in the very near future. I hope we can cooperate with Mexico on that. You know, NAFTA began in 1994, and during the past quarter century, the world has changed a great deal. Certainly there was no digital trade then. So a modernization was certainly called for, and the new USMCA did take effect on July 1st of this year. Perhaps the best news, however, is that despite threats early on by the US to withdraw from NAFTA, if Canada and Mexico did not accept some of the initial US proposals in the negotiation, there was in fact no break from NAFTA, and continuity is really important in terms of trade, confidence, and business investment. And this was not a foregone conclusion. The early US negotiating position included several points that have been termed poison pills. They were provisions that would not have been acceptable to Canada and Mexico. For example, the US started off by asking for a 5-year sunset, requiring renegotiation after just 5 years. This would have made business investment impossible. The US was asking for a massive increase in access to the Canadian dairy market and dismantling Canada's supply management system. This is something no Canadian government could ever accept. US also wanted elimination of NAFTA Chapter 19, which is the special appeal mechanism for adverse anti-dumping and countervailing duty decisions. The US wanted specific Buy American provisions for autos and light trucks that would have required a guaranteed share of US content for a vehicle to qualify for duty-free cross-border entry. This is unheard of in a free trade agreement to have one of the participating countries insist on its own specialized share of content as opposed to region-wide. Fortunately, these were all abandoned. Strong opposition from the US industry to withdrawal from NAFTA and to several of the US positions caused the administration quietly to back down. But really it was Mexico that led the way to an eventual deal. It saw a continuation of a free trade agreement as vital to its economic security, and so was the first mover. And in the summer of 2018, a deal was announced between the US and Mexico. Most important provisions were the automotive production regional content changes. A draft of the terms acceptable to Mexico and the United States was published. Canada had little choice but to come along, though it did get some US concessions on dairy and on Chapter 19. Canada also got a side letter carving out a significant number of vehicles from any Section 232 national security duties on autos, which were at that time being threatened by the Trump administration. So when all is said and done, the USMCA is in most part a reasonable update and modernization of NAFTA, which it surely needed. For example, as I mentioned, digital trade didn't exist in 1994, and so the USMCA addresses that subject. It prohibits customs duties on electronically transmitted products and sets limits on source code disclosure requirements. The USMCA also contains broad provisions to allow cross-border data flows and forbids data localization requirements, which would mandate that data be maintained in a specific member country. NAFTA was the first free trade agreement to include a chapter addressing protections for intellectual property rights. And the USMCA retains NAFTA's core protections for copyrights, patents, trade secrets, trademarks, and geographical indications. The USMCA's new provisions in this area include copyright terms extended to 70 years, prohibitions on circumvention of technological protection measures, such as copyright prevention codes on disks, many criminal and civil penalties for trade secret theft. In the realm of agriculture, the USMCA increases US dairy access up to about 3.6% of Canada's dairy market. That's not a huge increase, but it does not dismantle Canada's supply management system, but it allowed the US negotiating team to declare a victory on dairy. In return, the United States expanded import quota levels for Canadian poultry and sugar products. For US-Mexico agricultural trade, perhaps the biggest development is that the USMCA does not include special anti-dumping injury measurements that would have inhibited Mexico's fruit and vegetable exports to the US. Not everyone, of course, is happy with this, even though Mexico agreed to set floor prices for its tomato exports to the US as part of settlement of a longstanding anti-dumping dispute. Other produce is not being protected. During the past decade, the value of Florida's tomato, bell pepper, and strawberry production is down significantly, about a third, while imports from Mexico have increased. For dispute settlement among the parties, the governments, the USMCA maintains the NAFTA state-to-state mechanism for most disputes arising under the agreement, and it removes procedures allowing a party to block formation of a dispute settlement panel. This ability to block panels has significantly weakened the overall dispute mechanism under NAFTA. For appeals of trade remedy cases, such as anti-dumping and countervailing duty cases, the USMCA retains, as Canada had insisted, the binational dispute settlement mechanism of Chapter 19 of NAFTA as an alternative to appeals in the national courts. For claims by individual investors, however, USMCA eliminates investor-state dispute settlement, called ISDS, between the United States and Canada. It maintains ISDS only between the United States and Mexico, but with several limitations, which Alberto de la Peña will detail for you in just a few minutes. The US has had very good results from NAFTA ISDS over the years. According to the Congressional Research Service, foreign investors have never won a case against the US government in a NAFTA ISDS matter. So why did the US push to cut this back? I have read some speculation that the intention actually was to deter US investment in Mexico and Canada and thus keep it at home. NAFTA sets standards and parameters for government procurement of goods and services and opportunities for firms of each nation to bid on certain contracts for specified government agencies in the other nations above a set monetary threshold, but this would be on a reciprocal basis. The USMCA provisions apply only to US-Mexico procurement, while Canada remains covered by the more recent and comprehensive World Trade Organization Government Procurement Agreement, or the GPA. There were differences between the USMCA provisions and the WTO GPA. For example, the monetary threshold above which the agreements is to apply. And there are differences regarding to which government agencies and subunits the rules will apply. And where to buy American restrictions trump the USMCA. In short, implementation of the government procurement rules is going to be a complex, sensitive, and controversial issue going forward and will bear close watching. The USMCA makes numerous other changes and improvements to NAFTA, both substantive and technical. For example, there are binding obligations on currency misalignment. There's now a reasonable sunset clause, not 5 years and gone, but rather the agreement initially is to last for 16 years. And there's going to be a joint review at the end of 6 years, which would then push the sunset out to 16 years after that review. This gives business a long enough time perspective to allow investment and should be beneficial to all the member companies. The USMCA eliminates the need for a special NAFTA certificate of origin. Normal commercial documents containing all the requisite information will suffice. It's been suggested, however, that this may be a mixed blessing for businesses because in some ways the certificate of origin was a get out of jail card when the Customs Service came along to audit the entries and the duties. But now the companies are going to have to really show the data in their records to support duty-free treatment. Environmental and labor standards are now inside the agreement rather than inside letters. And they're subject to USMCA dispute resolution procedures. Mexico has agreed to be subject to the International Labor Organization standards and in fact passed a major labor law update in May of 2019. And that is one way in which the complaints of US labor may have redounded to the benefit of Mexican labor as well. Now, making these changes didn't require all the drama of the past 3 years. In fact, many of them were already in the Trans-Pacific Partnership, to which all 3 countries were originally parties until the US dropped out. The impotence for the drama, including the threats of termination and the hyperbole about NAFTA being the worst trade deal ever, was the decline in US-based manufacturing and industrial employment during the quarter century since NAFTA was enacted in 1994. These declines may have been caused as much or more by automation or by the growth of China as by NAFTA, but NAFTA was still an easy target. So the 2 most notable aspects of the USMCA to address these job losses are 1, the elements to protect US automotive manufacturing, and 2, the provisions to improve labor conditions in Mexico so that low wages and other low costs don't continue to pull employment south of the border. In the case of autos, the percentage of North American content to qualify a vehicle for duty-free entry is to increase over the next 3 to 5 years from 62% to 75%. 40% of the labor going into a car must be paid more than $16 an hour. That's likely in the US and Canada. There are additional rules requiring that a specific share of the highly paid labor be in manufacturing and not in research, design, and other already high wage occupations. And 70% of the steel and aluminum must be of North American origin. And that means actually melted and poured in North America. Now, it really remains to be seen whether these changes will have the desired effect, or will they merely raise costs, raise prices, and decrease market share, thus causing fewer, not more, cars produced in North America, and less, not more, employment? And will automation render futile any efforts to increase employment? Or will manufacturers just not bother with the changed supply lines, record keeping, and bureaucratic hassle, and instead find it less costly to simply pay the 2.5% standard MFN duty on complete vehicles produced elsewhere? I guess time will tell. Regarding labor conditions in Mexico, under the USMCA as negotiated and signed, Mexico promised and in fact took immediate steps to implement many reforms, including, as I mentioned, adherence to ILO standards regarding the right to organize and protections for unions. These reforms, however, without a more stringent enforcement mechanism, were still seen as insufficient by some members of the US Congress and some major US industrial unions to agree to support implementation of the USMCA. The result of this is that the Democratic chair of the House Ways and Means Committee, Richard Neal, negotiated with USTR Robert Lighthizer to strengthen the enforcement mechanism. And their agreement led to what is called the Protocols of Amendment, which were made to the USMCA in December 2019 and accepted by Mexico and Canada. The Protocols of Amendment includes what's called a rapid response labor mechanism. And if a US union or company believes that the workers at a covered facility in a priority sector in Mexico are being denied their rights of free association and collective bargaining, the US party under these rules may petition a special US government interagency committee that was set up by executive order late in April. The committee would initially consult with the Mexican government, which would investigate and perhaps resolve the problem. But if not resolved within 45 days, an investigating panel would be established with one panelist from a Mexican list, one from a US list, and one from an agreed list of neutrals. They would investigate, verify, report, and if it considered necessary, recommend remedies, including denial of USMCA duty-free status for output from the facility, or in some circumstances from the entire company owning the facility. And once a remedy is put in place, there's supposed to be ongoing consultations regarding whether the denial of rights has been corrected, with the parties determining in good faith when to remove the remedies. If they can't agree, then another panel is to be established to reinvestigate. Now, again, it remains to be seen how much this entire process will be used. It hasn't been yet, though the US AFL-CIO has said it's working on petitions. We don't know how smoothly it will operate and to what degree the parties can cooperate in using it to address appropriately labor conditions in Mexico. Again, only time will tell. Alberto?
Thank you very much, Ed, for your presentation. Excellent synthesis about the situation, some questions that may arise that we hope to be able to address afterwards. So without further ado, I would like to give the panel to Alberto de la Peña. Alberto de la Peña heads the Mexico and International Practice Group at Haynes & Boone. He is licensed to practice in Mexico, Texas, and New York. And he is working with Mexican and US companies for more than 23 years in advising. He's an expert on transactional law, NAFTA, strategic M&A, anti-corruption, and international law, among many other topics. Alberto, without further ado, the panel is yours. Thank you.
Thank you, Alfonso. Thank you, Roberto Velazquez and Ed Livo. You know, it is a great panel. I think a lot of good things have been said, and the great thing of it, the last one, is that I don't have much to say after those presentations, but I would like just to make a few points on very quickly, because I know we are crunch on time, about something that I think is very relevant for the companies doing business in the region, and that's the investment chapter. The investment chapter, you know, we had the investment chapter in the USMCA as well as we had it in NAFTA, and that chapter has kind of two sections. One is the substantive rules or the minimum standards to protect the investment, and the second one is the investor-state dispute resolution process. I will say that between NAFTA and the USMCA, what is related to the substantive part of the investment chapter remains mostly the same. I think there are big changes on the investor-state dispute resolution. So just talking briefly about the substantive part of the investment chapter in the USMCA, you know, as in NAFTA, it takes and adopts the principles of national treatment, the most favored nation, and as in NAFTA, you know, applies the minimum standards that each state must provide for the foreign investment, which is fair and equitable treatment and full protection and security on the international law, which we can, I think, translate as, you know, having due process and police protection. It also protects expropriation, both direct and indirect. I think the big difference are on the investor-state dispute resolution. And, you know, when NAFTA was adopted, this was one of the main, I would say, features of NAFTA that, at least for Mexico, it was the first time that the state was able to be subject to an international arbitration as part of a treaty. And this mechanism under NAFTA benefit all the parties, so investors from the three countries, you know, United States, Canada, and Mexico, you know, doing investments in all the North American region. In the case of the USMCA, they included this state dispute resolution process, but it is more limited and it is more restricted. First of all, it only applies between US and Mexico. So investors, you know, US investors in Mexico, Mexican investors in the US, and, you know, generally applies to violations of national treatment provisions or most favored nation or direct expropriation. And this is the general rule. And there is one requirement that did not exist in NAFTA, that is that in order to bring this international arbitration, the investor or the plaintiff, in this case, making the claim, must file and begin litigation in the state and either get a final ruling, you know, which we will assume is adverse, or at least litigate for 30 months. So they have to go through this 30-month process of litigation before they can resort to the international arbitration. Now, there are certain exceptions to this 30-month requirement of national litigation. And it is in the case of investment in government contracts in what the treaty calls cover areas. And the cover areas are oil and gas, power generation services, telecom, transportation services, and ownership and management of infrastructure. In those cases, this restriction does not apply. And, you know, that arbitration, the investors may claim violations to the whole investment chapter in general. So in the case of disputes between investors of Canada and Mexico, which are not regulated in the USMCA, then they will be subject to the TPP, which both are party to. And in the case of Canada and the US, I guess it will be the WTO. But again, this investor-state dispute chapter in USMCA only applies between US and Mexico, and it is in a way more restricted. The other area that has been touched, and I would like just to mention briefly that it obviously is really relevant, is the labor, right? The labor, you know, it's interesting that the new regulations in labor were adopted in Mexico before, obviously, the USMCA entered into force. And they have been there right now, as we speak, in full process of implementation. And basically, they prohibit, you know, interference of companies or employers with unions. And there is a guarantee that the unions will be elected by the employees by a direct vote. But what is more important is that now there is an independent verification process by the authority, by a governmental agency, that verifies that employees in a specific company elect freely the union they want to belong. And then once that process is done, there is a certification of the process, there is a registration of the collective bargaining agreement and the union, and each employee must receive a copy of the collective bargaining agreement. This sounds like common sense, but in practice, many times, you had employees that didn't have a copy of the collective bargaining agreement. So I think these two items are extremely relevant, particularly for investment in this case in Mexico and also in the US and Canada, but particularly between the relationship between US and Mexico. And the only final thing that I would like to touch that has already been mentioned in general is, the rule of origin and is related to labor, that 40%, in the case of the automotive sector, 40% of the cars and 45% of the trucks must be made by employees that earn $16 per hour in a 5-year period. So there is a transition period, but in 5 years, it's supposed to get to $16 per hour. Obviously, this is going to be also a challenge. The minimum wage in Mexico daily runs between $5 and $8, although some statistics say that in the case of the automotive sector, the average is $7, but still there is a gap that will have to be filled. And again, in terms of opportunities, changing the rule in the automotive sector of North American content from 62.5% to 75% may create opportunities, so we move supply chain into North America, particularly into Mexico, right? Or may also deter as we, in the sense that the threshold is too high. So those are kind of just general remarks that I think are very relevant for investors in the region.
Okay, thank you very much, Alberto. Very, very synthetic as well. Question, very, very synthetic. A lot of information, I have to say. I have just one quick question before opening the panel. We have few also persons that are wishing to participate and making questions. But is there or have been during the negotiation phase any topic addressed about the friction that may exist between the WTO, the TPP, and the USMCA in terms of who would be considered applicable in each case? Because listening to Ed and to Alberto, we could see that for Mexico and Canada, we envision a certain type, we were envisioning that the TPP would apply, and between Canada and the United States, the WTO. So during the negotiation, has anyone addressed these frictions that may exist afterwards? Are you aware about it? Any of you?
No, I can just say, I think the three countries have different agreements in place. For example, with Canada, we are both part of the CPTPP. The three countries are in the WTO, and Canada and the US also have the Canada-US free trade agreement. So we all share different instruments. And there are already mechanisms where companies, for example, can choose which of the different frameworks they use for exports. So I think that it was not an issue during the negotiation because we already have some provisions in place for that coexistence of different agreements.
Okay, thank you very much. I would like to, we have a few questions, but I have from the panel, I would like to let Guillermo Garcia Sanchez, professor from at Texas A&M, that would like to ask a question. Thank you, Guillermo. Please, welcome.
Thank you, Alfonso, and thank you to Alberto, Ed, and Roberto for all your comments. It's a fascinating panel. And I would just like to ask a question about the elephant in the room. And I think that most people would like to know the views about what are your views about what Chapter 8 was supposed to provoke. And just a reminder for those in the panel and the speakers, the chapter is the one that recognizes the Mexican state's inalienable and direct imprescriptible rights to regulate its energy sector. And as we know, there is a view, at least from President López Obrador, that chapter gives Mexico the right to modify the law and not compensate foreign investors, or at least there's no effect on those investors. And there is a view of others, as just Alberto mentioned, that yes, Mexico can change the law, and that's something that is recognized not only in the treaty, but also in international law, but that compensation has to be awarded to those investors that had invested in Mexico under the previous administration. So I would like to know everybody's views on that particular big elephant that is hiding in the room.
I mean, I can talk a little bit about that. One thing that I didn't mention is that any claim under NAFTA can be made 3 years after the NAFTA termination. So legacy claims, so anyone who made an investment under NAFTA still will have 3 years to make those claims. I think that's a great question. You know, that chapter that you mentioned is a very short chapter that in a way repeats the Mexican Constitution. But it does say that the text of the chapter itself, it says that that Mexico has the full sovereignty and sovereign rights over its own resources, but that's without prejudice of the rights and remedies of the parties available on the disagreement. So some interpretation has been made. I mean, I think there are 2 ways to say it. One is that Chapter 8 cannot, you know, you can change the Constitution, and regardless of whatever the agreement says, you know, you can, for example, revert the energy reform. The other interpretation will be that under the general exceptions chapter, which is Article 32.11, in the case of certain exceptions, it says that pretty much the minimum standard for changes are those that in the case the parties have adopted the less restrictive standard for the investment. And in the case of Mexico, I understand in the case of TPP, for the energy reform, Canada reservation of rights were those that are in the energy reform that are reserved to the state, which, you know, is obviously, you know, the natural resources are owned by the state, the transmission of the electricity, but besides that, it's open. So under that one, you know, there is an argument that couldn't be changed. But again, I think that's a matter of, from a legal point of view, not a political point of view, it is a matter that is still will have to be decided if that happens, and an investor start making the case and filing for this arbitration.
Okay. Yes, and let me just first say that I don't think it's a truthful interpretation of what our president has been saying to characterize it as that he claims that changes in policy and that affect investments in this sector can be made without compensation. I don't recall him ever saying that. Of course, he is aware about Chapter 8 in terms of energy. And I'm sure you know that there are some changes in the vision in the energy sector and the energy policy in Mexico. But obviously, any changes that affect investment have to be done in such a way that the legal framework in Mexico is upheld. Obviously, that also implies that laws and international treaties that apply to these investments have to be guaranteed. So that would be my clarification. And then afterwards, I would say that, well, in this point, it is very important to look at individual cases of the companies and see exactly what are the different claims and legal points that would have to be involved in each of them. So that would be it.
And it's also very interesting. Thank you very much for this clarification. And I think it's also very interesting to point out that as a comparatist, we need to know that Mexico has a codified origin system. And so we are applying the international law principles that apply to this type of countries. And the rights of property in the United States are different because they are seen from an Anglo-Saxon perspective. So this is also the way, and it's interesting how these aspects are being integrated because both are relevant. They are both different legal traditions and both have to be taken into account. So no, thank you so much. I would like to, can we think that is, what are exactly the dispositions that will be taken by Mexico in terms of environmental aspects? Are there any already planned in terms of how to, in terms of environment, how to address these issues? For you, Mr. Velasco, but as well for Ed and Alberto, what do you think about?
Well, I mean, we're obviously working in a common agenda for the Commission on Environmental Cooperation that was established in the side letter of the agreement. It's a body that has existed since the implementation of the NAFTA, and we intend to keep working for the different provisions that are in this updated letter. And as well as other relevant letters that were included in the NAFTA renegotiation.
Thank you very much. Is there any other question that you would like to address? Has anyone any question or comment? Well, thank you so much. We arrived to our time. We are 2 minutes away, but it's still reasonable. So thank you so much. I would really thank Mr. Velasco and Alberto de la Peña and Ed Lebo for their contribution. And hopefully we can, in the next few months or maybe in a year or so, do like a review about how this USMCA has been applied and the successes that I'm sure this is going to bring in terms of integration, trade integration between the United States and Mexico. Thank you everyone for being here. This seminar is going to be recorded, so you will have access in our webpage to it. If you want to watch it again or share it, feel free to do it. And hopefully I'll see you next time.